how we can interfere with the Court of Appeal's decision.
Once you get to the point where you are accepting that the disciplinary committee made an error of principle, then it is hard to keep the Court of Appeal out.
Right.
Yes.
Okay.
So I'm totally with you on that.
Okay.
What I am saying is that the disciplinary committee did not err in principle, and so that is where I'd like to try and take you to if I could.
Yes, the reason this case is being treated as one of general public importance is that guidance is sought as to the appropriate test for an intervention by a court in respect of a disciplinary panel's decision. Could I have very clearly, what is your submission as to the test? Is it the one that the Court of Appeal has stated at paragraph 30 on page 75? The intervention of the appellate court in matters of sentencing imposed by the disciplinary tribunal ought to be limited to cases where errors of law exist or where the sentence is demonstrated to be clearly inappropriate.
Yes.
Is that the test?
I wouldn't fault that test. That certainly falls within the test.
You're happy with that test?
Yes.
Thank you.
Because we're saying there were no errors of law and that the sentence was appropriate. But in further answer to your Lordship's question, there is also the test of whether the conclusions of the committee are supported by tenable reasons grounded in the evidence.
So that it must be adequately reasoned.
Adequately reasoned.
But this isn't a
So
reason.
there would not be, it would not be unreasonable. And if it is not unreasonable, there is no basis for interference with it.
Yes, but there's no reasons challenge, as Lady Simler says here. You don't have to address a challenge based on the inadequacy of reasons as such. The challenge that you're facing is that there has been at least an implicit finding by the disciplinary committee of there has been a test of applied in relation to dishonesty, but no finding of dishonesty. I think
yes,
would be the appropriate way.
And I don't think it was so much of a opinion. I think it was dicta that they were quoting, as I said, not necessarily giving rise to that presumption. But and that, of course, your Lordship has just highlighted the very two issues that we were given permission to come here on. Those two issues set out by the Court of Appeal, the test for when to intervene. It is submitted by the General Legal Counsel, my Lord, that to warrant the Court of Appeal's setting aside of the striking off, it must be that it was incapable of being a just sanction. And that also is also in part answer to your Lordship's question about when is the threshold for intervening.
Yes.
Once it is just, once it is correct, once it is not wrong, once it is appropriate, there is no need to intervene.
But is that just a reformulation of the second part of the test set out by the Court of Appeal, paragraph 30?
Yes.
Where the sentence is demonstrated to be clearly inappropriate. So there are two possibilities. One is whether you call it error of law or error of principle, and the other is even in the absence of error of principle, the sentence is demonstrably inappropriate.
Yes.
I mean, the fact that the Court of Appeal disagrees is not a sufficient reason, because there may be cases in which there's more than one sentence which could be reasonably be arrived at without it being outside the permissible range.
Which is where is
And you say this is that case.
This is that case, and I want to go a little further, if I may, my lords, because I think there was the Court of Appeal and approach to the issue of appropriateness as being mutually exclusive with harsh. So if you look at EF page 69 at paragraph 18.
Yes.
And I'm looking at, say, about 5 lines from the bottom, where it says, however, the approach that is recommended to be taken in this analysis, that is this analysis by the Court of Appeal, is to focus on the sanction of striking off itself in the circumstances of this case. It will either be found to be appropriate or harsh. Therefore, and so on and so forth. So they are drawing, the dichotomy there is between appropriate and harsh.
They should have said unduly harsh or something like that, probably.
And because we're submitting that approach is flawed, because that the sanction of striking off is harsh, is inherent in an order striking off. It is possible for an order to be both harsh and appropriate. The function of the Court of Appeal was to determine whether, on the facts of this case, the striking off order came within the bounds of what was just. Many authorities, my lords, including Bolton, say that misconduct of the nature that occurred here would ordinarily merit a striking off. If your lordships remember the facts of that, you would know that that was a case where the attorney was 2 years in the bar.
Is this, sorry, is paragraph 18 their conclusion, or is it part of the summary of what the argument was?
No, my lord.
Because it's saying the approach that it is recommended to be taken in this analysis, and they've been discussing what the council was arguing for.
Yes, I did not read it that way, my lords. I read it, when I read the whole thing, it appears to me, and there is
Well, this is a summary of the council submission, so when it says it's recommended to be taken, that surely is saying what council is recommending the court to how they're recommending the court to approach it.
And the test they set out is
paragraph 30.
The heading discussion,
Discussion, yes.
It starts at 27.
but the summary of the submissions follows that on the next page. It's not on that page.
So, the summary of submissions, that's moving on to ground D,
Yes, that's right.
the hearing of the appeal, and then they summarise submissions on the sanction of striking off.
But 18 comes at the end of an